Thank you so much, Caitlin, for joining us today. As Keith mentioned, this is a joint session of the Bankruptcy and Insolvency and the Blockchain and Cryptocurrency practice groups. Really appreciate your time. Obviously, there's been even since we've emailed to set this date, I think a couple months ago, there's been a lot of developments in the space. And so one of the things we're really interested in, one is thank you for being here. I think everyone's well aware of your background, your expertise, and not only in the traditional finance arena, but also how that plays out in the digital asset space as well. And so maybe just to start, Caitlin, I'd really like to just start with the basics and get an understanding of, from your perspective, whether there is a difference between Bitcoin and the rest of the cryptocurrencies. And if so, what exactly makes it unique in a sea of kind of endless coins that appear seemingly every day? And then maybe we'll get into more the in-depth discussion of how traditional bankruptcies and these exchanges have played out and kind of go from there, if that's okay.
Yeah, that sounds great. First, some quick background. I'm trained as an attorney, but I've never practiced. I'm a non-practicing member of the New York Bar, and so have some background, and it came in handy in some of the structuring work that I did during a 22-year Wall Street career. I ran the pension solutions business at Morgan Stanley in New York, moved back to my native Wyoming to help basically define in the law, property law and in commercial law and in banking law, what digital assets are at a state level. Of course, the Uniform Commercial Code is a state level law. And Wyoming incidentally is where the LLC was created in 1977. And some of the people who were involved in that are still around. And they recognized that what Wyoming was doing in defining the legal and regulatory status of digital assets under the UCC was essentially another version of that. And indeed, what we've seen is that the Uniform Law Commission picked it up, changed it. We can talk a little bit about the changes that they made that caused a couple of red state governors to veto the Uniform Law Commission version. But needless to say, that there's a long history in my native state that most folks don't recognize. And I moved back in 2019 before COVID to help the state get this off the ground and formed a bank, Custodia Ban, that was chartered in 2020, applied to get an account at the Fed in 2020 and was denied that account unlawfully and is in litigation with the Fed as we speak. Obviously, I won't speak about that, but that's the background. So now to your question, is Bitcoin different? Yes, Bitcoin's different, and the lawyers would recognize that there's one very simple reason that Bitcoin is different, which is that Bitcoin is acknowledged not to be a security. And so if it's not a security, we don't quite know what it is. Is it a commodity or is it money? Again, under commercial law, the definition of controllable electronic records recognizes all forms of digital asset. The state of Wyoming and a few other states have recognized it as money for commercial law purposes through an addendum to the UCC, an interpretive addendum for digital assets that relies on UEDA. But needless to say, there is not regulatory clarity, but there is clarity on that one point, which is that everything else other than Bitcoin and digital assets has a cloud in the United States over it as to whether it's a security or not. From a technology perspective, the technologists would say it's massively different as well. And that is because of the way that Bitcoin comes to consensus. A lot of folks who are not technologists have trouble understanding what this whole thing, digital assets, is. What it is shared infrastructure. It's a shared ledger that multiple parties who don't know each other necessarily, or who certainly shouldn't trust each other, can use that shared infrastructure so they don't have to duplicate and reconcile the same information. It is staggering how many times a single transaction is duplicated and reconciled in the current structure of traditional finance. The average payment is duplicated and reconciled 6 times. Stop and think about, because it's hitting a data center all 6 of those times, it's hitting somebody's data center. Stop and think about how wasteful that is from an energy consumption perspective. That puts into perspective the concept of a distributed ledger that's shared among all the users that only has to confirm that transaction once. And so while that single transaction might use more energy, as a whole, it uses less.
That's excellent point, and I think it's key for people to understand the true, the inherent value of being able to kind of modernize traditional financial system. And I think you hit the key point there, which is, it really allows commerce to come into play without really a middleman, right? You can
Correct.
create these transactions, trustless transactions. Love the mug. Thank you for that.
Cheers.
One thing that really, the FTX, Celsius, Voyager, I mean, all these other kind of centralized exchanges, maybe for lack of a better word, really put, for our practice groups, put this on this discussion on our radar. What was, have you seen a common theme of what brought down these exchanges? Go ahead.
Yeah, sure. There is a common theme, but there's also in particular cases outright fraud. Okay, but the common theme for even the non-fraudulent ones is they got themselves leveraged. They were playing the traditional finance game. And coming from traditional finance, some of you have known, I've been pretty critical of the privatized profits, socialized losses approach to traditional finance. There's a lot of instability in traditional finance. We just witnessed it with the failure of several banks. And there's a sort of Damocles proverbially hanging over every financial institution because they're leveraged. They undertake maturity transformation in the case of traditional banks, where everyone who thinks that they can and should get their money back immediately upon demand, if they all come at the same time, guess what? The small banks have on average 7.5 cents of cash. And so they can only take 7.5% of their demand deposits showing up at the same time. The big banks are not that much better. They're a little over 10 cents, right? So you can only have 1 in 10 depositors show up at the same time and have the bank survive. So this is fundamentally unstable, always has been. The world has woken up to it. Online banking has sped up bank runs. All of those things are true. But what happens is that there's a lender of last resort who can come in and do these bailouts. That does not exist in crypto, and it will never exist in Bitcoin. Why? Because no one's ever making more than 21 million Bitcoins. Okay, and so I've been warning about this. I started writing about this for Forbes 5 years ago, but privately warning a lot of people about this after I left Morgan Stanley in 2016. Wall Street should not come in and play its traditional leverage games. Those traditional leverage games rely on the privatized profits, socialized losses business model, where there will be bailouts that ultimately come from US dollar owners through the Fed when big financial institutions that are systemically important fail. And that is not the case in crypto. I applaud the fact that the regulators have allowed these institutions to fail. I hope that they learn. Although just today, we're recording this on, what's the date? June 27th. Just today, the leveraged Bitcoin ETF started trading, and I tweeted out a vomit emoji on that. Leverage and crypto do not mix. This is going to blow people up. And my fear is that it will blow up traditional finance, because one of the things have been warning about since 2018 is the commingling of these exposures in large clearinghouses like ICE Clear LLC, which has been clearing Bitcoin futures. You start allowing for collateral substitution. You start commingling the liabilities in systemically important clearinghouses. Oh boy, folks, this is a terrible idea. I cannot warn federal regulators more loudly. Stop this. It needs to be ring fenced. It's a different animal. It settles faster. And if you leverage it, the moment someone goes over one-to-one leverage, that's what I mean by leverage. Up to one-to-one leverage is fine. The moment somebody goes over one-to-one leverage, they are by definition insolvent, and it's only a matter of time before they fail.
Yeah, and you mentioned too with the technology and the way these instantaneous transactions can happen, that it exasperates that issue. And I don't think I wish I had this clip I could show everybody, but you on stage, I forget where it was a conference with Sam Bankman-Fried, basically chastising him for leveraging. And, a couple of months later, the emperor, everyone found out the emperor didn't have any clothes on. And that, I think, to your point, is a great example of just outright fraud at the end of the day.
Well, allegedly, he was doing both. He was leveraging, but it was also, it would appear outright fraud. And I will pause there and say that I have publicly stated that I was working with law enforcement. I came into some evidence of probable crimes having been committed by one of the big frauds in the digital asset industry almost exactly a year ago, and started working with law enforcement to get them that evidence, because I knew that there was so much just, outright crimes, but also scams, and then highly leveraged business models. So the scams are the ones where there's a gray area. The highly leveraged business model, there's no gray area. None of these companies should ever have been as leveraged as they are. But I have to stop and say, at this point, here's the challenge. Those of us who were trying very thoughtfully to create a legal and regulatory structure that fit within the US regulatory system and worked, the state of Wyoming started working with the Federal Reserve in 2018. It is public information that there were more than 100 meetings between the Federal Reserve and the state of Wyoming in creating this new special purpose bank charter that is designed to ring fence digital assets from the traditional banking system and not infect it with the problems that we've seen. And unfortunately, when push came to shove, after multiple of us have tried, the Federal Reserve rug pulled the state of Wyoming, after having again worked years and more than 100 meetings with the Federal Reserve commenting on the draft bill language, the public rules, which went through 2 public rulemaking processes, and then the supervisory exam manual. And the state of Wyoming rightfully thought everything was ready to go. And then boom, at the end, it's the Federal Reserve said no unexpectedly.
And can you help us understand a little bit the importance of becoming a member of the Federal Reserve and what that will do for Custodia and your mission with that new bank?
Well, Custodia applied to become a member and was denied. So we have no pending application and have no intention of reapplying. Okay. But becoming a Fed member bank, all that does is you own the shares of the regional Federal Reserve banks, which are privately owned nonprofit corporations. They are hybrids in the sense that in some cases they like to pick and choose when they want to be federal agencies and when they want to be private corporations. But there's no question that the Federal Reserve Board of Governors, which sits over the top of the 12 regional Federal Reserve banks, which are legally owned by their members. And one of the things that came out in the Silicon Valley situation is that the CEO of Silicon Valley Bank was a director of the San Francisco Fed, which was the regulator of Silicon Valley Bank. So there are some very interesting, shall we say, I'm being facetious here, insider favoritism allegations at the Federal Reserve.
Sure. Well, thank you for that. We've mentioned Custodia Bank a little bit. My understanding is its mission is really to be a custodian of these assets, or if I'm wrong on that, can you help us understand a little bit of that?
Yeah, so the Wyoming Special Purpose Depository Institutions are designed to be non-leveraged banks. Again, there's a very fundamental reason we just talked about. You go over one-to-one leverage and the financial institution is by definition insolvent. We should come back and talk about the prime trust situation, which is evolving as well. But literally, if Sam Bankman-Fried had tried to get a Wyoming bank charter, he would have been laughed out of Wyoming. Same thing with prime trust. Now, what do I mean by that? Prime trust allegedly was rehypothecating customers' assets. Most lawyers understand what that means, but a lot of folks on Twitter are talking about, wait a minute, how is it that a trust company, which is supposed to be holding assets in trust for its customers, was turning around and lending its customers assets? Well, and by the way, then because of all the leverage bubble that was created in this sector that subsequently collapsed, allegedly there's a hole on the balance sheet, and you saw last week the Nevada regulator has frozen the company. It is not clear whether that will be put through a receivership or whether that will be put through a Chapter 11 filing. That becomes an interesting topic for discussion in terms of the statutory segregation of assets, right? A lot of folks thought trust companies didn't lend, and they're not supposed to, but this concept, rehypothecation, this big word, scary word that the average person on the street has no clue what that means. But what that means is that effectively these trust companies that were supposed to be holding one for one real assets against their trust liabilities were out there leveraging their customers' assets. And allegedly, there's a hole on the balance sheet. Well, the hole on the balance sheet has been confirmed. Okay, but we don't know exactly what caused it. Now, coming back to your question about the Wyoming special purpose depository institutions, rehypothecation is a banned practice for Wyoming special purpose depository institutions for this very reason. The concept is that the institutions should be money warehouses. Digital assets are bearer instruments. And we can go back to the concept of what is a bank. There's no reason why your bank has to be your counterparty. Your bank can basically be a bailee relationship, just like a garage, a parking garage where you park your car. You're not handing legal title to your car over to the garage, or a coat check. You're not handing legal title to your coat over to a coat check. What you're doing is handing over your property for temporary safekeeping, and you retain legal title to it, so that if that entity, the garage or the restaurant, goes bankrupt while your car or your coat respectively is there, you don't have to go through a bankruptcy court to get it back. And it is very clearly not the property of the estate of the safekeeper. Okay, so a lot of folks will look at that structure and say, well, wait a minute, it exists in securities custody today, but I'm going to get very wonky here. It's interesting, if you look at securities custody is done through UCC Article 8 almost exclusively, where legal title is sitting with the depository trust company. And therefore, if you have a bailment on an IOU as opposed to a bailment on the actual underlying property, how meaningful is the bailment on the IOU? You see where I'm going. But a bailment on the actual underlying property, that's meaningful. Yeah. And that's what the Wyoming special purpose depository institutions are designed for. We are, when I say we, I'm talking collectively, all the Wyoming regulatory regime plus the 4 chartered banks are very different. And it is a nod to the nature of digital assets being bearer instruments on which you can create a meaningful bailment. Now, there are a lot of details, so I'm speaking generally, of course, not giving legal advice here. The customers have to look through the agreements, because the Wyoming special purpose depository institutions are authorized to offer omnibus accounts as well. I will say in Custodia's case, Custodia is not. Custodia is offering segregated accounts, but we're not doing it yet. Stay tuned. I did publicly disclose that Custodia submitted its 60-day notice to the Wyoming Division of Banking to start launching Bitcoin custody. And so when Custodia does launch Bitcoin custody, something new and truly different that has different bankruptcy and receivership structure will come onto the market. And that is true segregation, a legal bailment, and because Custodia is a bank, all these Wyoming special purpose depository institutions are banks. Now we'll start to get into the bankruptcy distinction between a bank and a non-bank. Banks have special receivership rules in statute. And that means that the segregation of assets is protected by statute. I think I don't need to lay out for you what that means. When you've got statutory asset segregation as compared to contractual asset segregation, there's a big difference.
Sure, and I think a lot of the retail investors on some of these exchanges are finding out the hard way through these bankruptcy proceedings, right? The bigger question is, did they retain any rights to those digital assets that they had sitting on those exchanges? And correct me if I'm wrong, I think the general answer right now is no, because as you pointed out, the terms of the agreement said, you basically don't have any rights once you put these on our exchange. Is that correct?
Well, again, I can't speak to the specific situations, but in general, that is indeed the case. There were a lot of outcries by retail investors in some of these bankrupt institutions that they did not understand the nature of their agreements.
Yeah.
And actually, I think in most of those cases, the lawyers probably did construct the agreements to warn them, but they didn't understand what that was. I have an issue with the concept of using the word rehypothecation in customer agreements and not explaining it. Go look at your brokerage agreements. That word appears in probably every single one of your traditional brokerage agreements, but it's not defined in almost all cases. And how many people really understand what it means?
Yeah, that's a great point. And again, going back to this idea, I mean, these aren't new techniques, right? These are basically from traditional finance applied to a largely unregulated environment. And I think we're seeing all of that come to fruition. I want to stop real quick. We have one question, and feel free, guys, put it in the chat box. I'll do my best to get them answered. Says, if crypto should not be leveraged, then what is its value as an asset? Is it even a property? If it's not property, what is it?
Oh, it's definitely property. I like it as a technology. I've said for years, the price is the least interesting aspect of it. Now, the reason that it is enforceably scarce is because there is a token of scarce quantity. And so you cannot divorce the fact that there's something scarce. If something is, it really what it is a digital collectible. And if it's scarce, then just like any other collectible, it may have value. You can't divorce the technology from the token. I wish you could, because that would take a lot of this crap out of the sector. And I've said, I still think, in spite of the leverage flush, probably 90% of what's left in this industry still needs to go away. Okay, I mean, we saw that, with the Prime Trust news last week, and there was another company that had several state securities commissioners move against it as not disclosing to its customers that it had allegedly been insolvent for a while. So, look, we're not done yet, I think, with the flush of leverage sorry, I just saw the crap as a technical banking term. Yeah, exactly. Look, there's a lot of that in the traditional financial system too. It's just that, thank goodness, there are not bailouts happening in this system, and so the leverage flush is being allowed to happen a lot faster than it would in traditional finance. But yeah, sorry, I ended up going off topic there when I saw that pop up.
That's okay. And it's interesting too, right? We now have, to your point, we have a leveraged Bitcoin ETF that's been allowed to come to market, and yet a spot Bitcoin ETF that, the various entities have been trying to get approved for the last couple of years still hasn't been approved. So that's kind of an interesting juxtaposition where, again, you're allowing the leverage, which is, a lot more risk to it, rather than just giving access and exposure to the spot Bitcoin ETF.
Yeah, I mean, the purists would say, well, that's a cash settled future. So it's you're putting leverage on a cash settled future rather than a spot future, because the spot ETF has not been approved yet. And the SEC has, I don't know, there are dozens of applicants for spot ETFs that have either been denied or had their applications just expire. And one of the biggest issues is that there isn't market surveillance. The SEC has been noting that in most cases, that there is market manipulation, and no doubt it's true. But again, I come back to, all right, for those of us who tried to create a legal and regulatory regime that fit within the existing legal and regulatory system for this new asset class. So coming back to answer the previous question, yes, it's property. Yes, it's a token. Yes, it has value. And frankly, most Americans can't see that value because we have the US dollar. But oh boy, look at emerging markets. There are a lot of emerging markets for whom, where average folks are using this as a means of transacting and as a means of saving that is more reliable than their home currency. Lots of folks, there's a big divide here between the developed world who can't fathom that, and the developing world for whom they are so grateful that there is something other than their traditional currencies. Look at Nigeria. Nigeria tried to roll out a central bank digital currency. And you know what happened? It made Bitcoin adoption go up because people looked at it and said, oh, I don't want this government thing. I don't trust the government. I would much rather have this decentralized money that nobody can print more of. But coming back to the question of US regulation, this is what I lament, because it's like the internet itself. Okay, when the internet itself came along, I was around in the 90s, and I remember it all the debates. Are we going to try to block some of this? And thank goodness the Clinton administration did not. And the Berman Amendment came along and said, all right, if a packet gets routed through a country that is sanctioned, that doesn't mean that the user of the internet has violated OFAC. But now with money, we're making that distinction. Keep in mind a packet of information coming across the internet, whether it's information or whether it's money, there is no such distinction. It's all information. It's all bits and bytes, right? And so, yes, if that happens to get routed through a sanctioned country, oh boy, you can't do that, right? So we've just now created this artificial distinction that the technology itself doesn't recognize, but the federal regulators are trying to jam in. But what they don't recognize is because to be honest, I see a lot of lawyers who don't understand the technology writing policy for this. Bad idea. As a trained attorney, my former, never practiced, but a dormant attorney myself, I can point a finger a little bit more than the average person can. It is not a good idea for a lawyer who doesn't understand how the technology actually works and can't actually get their fingers wet in the technology because they're prevented by the ethics rules from owning any digital assets. Boy, they should not be writing policy for this. And unfortunately, what we're seeing is that the policy that is coming out is trying to throw the whole baby out with the bathwater, take the entire sector and shove it offshore, but and into the shadows. But let's come back to the way the Clinton administration handled the internet. Most people don't know how to transact use the internet using the command line interface. Okay, most of us use some sort of a web application to make the user experience easier. Most of us don't use Tor. We use a browser. Most of us don't make our phone calls from the command line interface. We use Verizon, AT&T, T-Mobile, etc. So the same approach, I think, needs to be done with regulation in the United States, that you want to create a better user experience so people voluntarily go to the regulated entities. And that's where the security is better. That's where the user experience is better. And that's where law enforcement can ensure that the platforms and the companies themselves can ensure that the platforms are not being used for child trafficking. Okay. But this is technology that cannot be censored. Ergo, just like the fact that Tor exists, but most people don't use it, Bitcoin exists and most people won't use the actual base layer Bitcoin. They will want to go through intermediaries. But now stop and think about how wise the US policy is that is blocking all regulated intermediaries and shoving the whole thing into the shadows and shoving it all offshore. Wow. People are getting, there's been a lot of noise around Tether for years. And people, look, Tether's been getting its US dollars from somewhere, right? It hasn't ended yet. And so ironically, by trying to shut down some of the more regulated lit US markets, they've shoved the activity into the non-regulated dark US dollar markets that are offshore. And Tether now has an all-time high in terms of quantity of Tethers outstanding. And it's getting its US dollars from places that are not friendly to US regulators. The US regulators are getting exactly what they feared by doing what they've done. I think cooler heads will ultimately have to prevail. The US is shooting itself in the foot right now. I saw an interesting article from Chris Giancarlo, former head of the CFTC, who's in Tokyo. And there was he posted a photo of a headline: US foibles in crypto create incredible opportunity for Japan. Yeah, the rest of the world hasn't stopped and is moving forward. In fact, I just saw a headline today that Europe has has landed on capital requirements for European banks that hold digital assets on balance sheets. Wow, they are so far ahead of the US. And it is fun to go outside of the US as someone who's in this industry and watch how the rest of the world hasn't stopped, even though the US is trying to.
Yeah, and that's a good segue into kind of what the SEC has been up to the last year or so. Rather than, I think what most in the industry would prefer, which is, tell us what we need to do to be in compliance and try to service this market. They were kind of going backwards now, and to your point, the end result is pushing a lot of this stuff offshores, which is where a lot of the fraud and a lot of the bankruptcies have happened, were these offshore entities. If you had a kind of a magic wand, what would your preference be for the SEC, if they're even the appropriate regulatory body to approach this industry in a way that's going to help, again, meet consumer demand here in the United States?
Well, it's interesting because our chief compliance officer, Howard Plotkin, many of you know him. He's a real name in the compliance field. He and I were at a conference last week, and he said, listen, this is derivatives all over again. I even see this, I can tell you the names of the players, right? Back in the 90s, no one really knew what a derivative was. Is it a commodity? Is it a security? Is it money? The answer is no, it's not any of those three things. And the same thing's true with digital assets. It doesn't fit with those in those three categories cleanly, right? So what ended up happening is ISDA got created. And then of course, there was a deal cut with how it was going to be federally regulated. And I think his observation is probably right, that there will ultimately be a deal cut for federal regulation. Now, that said, the SEC, of course, wants all this because they saw what happened to the SEC in the derivatives world when it ended up going to the CFTC. And I think I've been very nuanced in the way that I've talked publicly about the SEC's action. Again, the Custodia is a bank. Custodia is not an SEC. It's not trying to do things that are issuance or broker-dealer type activities, right? We're a bank, lawfully a bank, ergo the Dodd-Frank exemptions that from securities law that apply to banks apply to Custodia. So we're in a different zip code. I don't spend a lot of time on securities law issues, which is where most of the lawyers who practice in this area are spending their time. But I've tried to call balls and strikes. The SEC probably let too much activity go in this space. And there were too many people who were defrauded as a result of it by not for years telling us what is a security. I mean, it is incredible that we're almost 10 years into Ethereum and they haven't, the SEC hasn't disclosed yet whether Ethereum is a security or not. I mean, at some point, just at the passage of time, I think a federal judge is likely to look at that and say, all right, due to the passage of time, you kind of lost your window there. And now I realize the lawyers will argue with me on that, but you can't sit in that gray area for 10 years. And I think part of the reason that they didn't come out and say it is or isn't a security is that it would have been challenged in court, and they weren't probably confident in the answer, in the outcome, as to whether it would survive a legal challenge. That's part of the reason why they just sat on it. Okay, so this is where the impotence of Congress is a problem, and it's going to be interesting to see. My gut tells me that if that lawsuit comes out and says XRP is not a security, then Congress may very well step in, because that just throws the whole thing into upheaval. Because if XRP isn't a security, that all of the other things that were issued similarly in similar structures may very well now have an even bigger gray area as to whether they're securities or not. And so I think, but candidly, from what I can see, I don't think anything's going to get through Congress unless something like that were to happen, and then maybe something gets through Congress. But the SEC has definitely made their life harder by doing some of the things that they have done or omitted from doing.
I think that's well said. Does anyone have any other questions for Caitlin? I have a couple, but I don't want to hog it. Ray, I don't know if you have any specific questions, if you're still on.
I'm still here. And I've been listening very intently to this, and what I'm hearing is that there's very smart people in the world who would do anything to make money. And it almost sounds like this is no different than some of the other crises or issues that we've had in the past. You can go back to the early 2000s and the fraud that we had with Enron and WorldCom,
Sure.
Adelphia, where
I remember all
people are
those.
trying to create
Yeah.
off-balance sheet transactions. And then rolling forward, about another 5 to 8 years, we had the subprime mortgage market and securitizations and, high risk taking, high reward transactions that eventually, over a course of 2 to 3 years, because I was intimately involved in all those transactions from 2005 to 2008, to bring the United States banking system, right to the precipice of, falling off a cliff. And I think the common theme here is no matter what it is, whether it is securities, whether it's banking, whether it's mortgages, now whether it's, cryptocurrency, it's you have very, very smart people who want to get to the line. Some people go over the line. Some people go right up to the line in how to make money, how to monetize assets. And that's what I've heard for the last 45 minutes. And I think it's very interesting. And I see it fitting very well into what Enron did and what WorldCom did and what some of the sketchy, that would be the legal term, sketchy banks did in 07 and 08.
Yeah, but think about power trading, right? Think about Enron in the post, think about power trading in the post Enron world. Did it go away? No, absolutely it did not. What happened is that the legitimate law abiding parties stepped up and filled the void. And were there regulatory reactions to that? Sure, absolutely. Is the same going to happen here?
Sarbanes-Oxley. I mean, every time there's a reaction, every time you have a meltdown, there's a reaction. So Enron, WorldCom, you had Sarbanes-Oxley. With the financial institutions, you had Dodd-Frank. So when cryptocurrency goes over the edge, then you're going to have some strong United States federal reaction in regulating, I'll use the term loosely, commodity. I don't mean it in a legal sense, but regulate the area.
So and it hasn't happened yet.
Suchai's question about where do you think, Caitlin, the regulation should be focused?
Well, I think it's like derivatives. We don't know where it's going to land, but it will land somewhere. And here's one of the ironies of the states stepping up to fill the federal void is Wyoming, the state of Wyoming handed to the Federal Reserve a legal and regulatory structure that worked. That frankly, if the Federal Reserve hadn't been so arrogant about a flyover country state being the one that created it, then they would have already had it in place and could have already used it, including for stablecoins, right? If they wanted to elbow Tether out of the market, the easiest, they'll never make Tether completely disappear in my opinion, because again, this is just code, right? 8 billion people on planet Earth can run code on their smartphones if they know how to do it. They'll never make it completely go away. So what's the right regulatory approach? It's create the regulated lit market swim lanes as opposed to forcing everybody into the dark market uses. And so ultimately that they could have done that. They could have done that when the Wyoming Special Purpose Depository Institution Charter went live in 2019. There are other states that have similar charters. There are actually 5 states that have uninsured bank charters already that could be used for the same thing. For those of you who practice in the fintech area, they are basically the payments charter. There's been a fight in the fintech world over whether there could be a federal payments charter, the OCC fintech charter or OCC payments charter. Those are terms that you might recognize from years past. It got litigated by the state of New York that the federal government can't elbow its way into state territory on banking. And so it didn't go anywhere. But the point is, there's a state version of that in 5 different states. And by the way, there's a former Federal Reserve governor who's a part of forming one of those banks in the state of Connecticut right now, having nothing to do with crypto. There's been clear allegations in just in the past year of a revolving door favoritism by the Federal Reserve when a former Fed governor gets involved with an applicant. This is the reserve trust situation. And now there's a former Fed governor involved in an applicant again. And let's see if the Federal Reserve gives it favorable treatment relative to the rest of us. Legally, they cannot. Legally, the law says the Federal Reserve shall provide services to all eligible depository institutions. So coming back to who gets the regulation, I mean, heck, the Federal Reserve had the ability to grab it and run with it years ago and didn't. Why? Because it wants a federal version of that. And it didn't want the states to get out ahead, but it doesn't have the legal right to pick and choose. It does not.
And this isn't, Caitlin, this, the crypto space is not the only policy area where I think, Congress has been failing to act over a number of years. And then you see the states kind of, like, to your point, step up and fill the void, right? Consumer privacy laws. We've had a number of states pass a couple of those because it's probably never going to get passed at the federal level. So Wyoming, you mentioned, I knew this, I didn't realize it was all the way back in 1977, but, created the LLCs, which obviously changed corporate structures here in the United States.
Yes.
For the better.
Absolutely, yeah.
And you're obviously very intent on keeping Wyoming out in front, on the forefront on this. Is there anything else that the state can do to encourage a more orderly structure to the market here?
Well, this is interesting because, well, no, I mean, Wyoming has passed in 6 legislative sessions since this whole thing started, this whole movement started. It's passed 33 different laws, depending upon how you count them. So it's defining crypto as property so that fraud laws and theft laws apply. It's defining what it is under the UCC. So parties know what the rights and obligations in commercial transactions are, and a judge has a roadmap to adjudicate disputes. And then it did a lot of clarification on taxes, including for sales taxes, and some states have done mining tax exemptions. And then, some states, Wyoming didn't because it doesn't have a state income tax, but some states have allowed the payment of taxes in digital assets. And then Texas just very recently got a lot of headlines because all the digital asset companies that operate in Texas are required to do cryptographic proof of reserves. That is indeed part of what the Wyoming Special Purpose Depository Institutions are. Now, one of the things that bothers me is that it does appear that there's a big incumbent, again, illegally, a big incumbent preference coming out of the agencies in Washington, D.C., all of them, right? They want their big buddies in New York to be able to elbow out the nimble startups in flyover country. New York and San Francisco especially, right? But even San Francisco is being elbowed out by New York because the federal agencies, you're right, this is the BlackRock ETF that I'm alluding to. It does look like there's something very real here that the nimble startups are not the ones that the federal agencies want to get through the door first. That is not legal, okay? And if it is proven that that is indeed the case, then the judicial system is the remedy for that. And Congress holding hearings, you're hearing the allegations of that coming out with regard to the SEC. It'll be very interesting. Look, a lot of people are going to be watching whether BlackRock gets that ETF through, in spite of the fact that dozens of other applicants have been shoved to the sidelines. And the same thing is true with Custodia and its master account. Bank of New York Mellon is doing the exact same digital asset custody business that Custodia revised our business plan and resubmitted to the Fed after the initial rejection back in January. And Custodia was voted down a second time on the business plan that is exactly the same as incumbents.
Well, and you mentioned the BlackRock ETF. I mean, I think they've only had one not approved in their history of filing for those applications. So to your point, they obviously have gotten word or have seen something that they like, that they think they can get it through, and which kind of interesting there too. I mean, I think they're using Coinbase as their as kind of their partner in all of that. So, and obviously Coinbase is, in litigation now with the SEC as it is.
Well, and also because this is a bankruptcy themed discussion, one of the interesting things that the SEC did that I agreed with is required Coinbase in, I think it was its Q2, maybe it was Q1 2022 10Q, to disclose the risk of what would happen in the event that it went bankrupt. The fact that every customer could become a general creditor. All of us who know anything about the law in this area recognize that that is a risk. And the SEC required very specific disclosures by Coinbase. And at the time, it prompted a big brouhaha in social media. Oh my gosh, Coinbase is going bankrupt. And I looked at that and laughed and said, no, that's not what it means. What it means is that the SEC is getting serious about the recognition that there is a difference between having a statutory receivership regime that typically applies to banks and broker-dealers and does not apply to non-banks and non-broker dealers. Okay, and so to your point, the custody structure of that ETF is using a state chartered trust company. Now, there is language in New York law about receivership, but here's where I would like to hear the bankruptcy experts talking about whether federal bankruptcy law trumps a state's special receivership regime that applies to a non-bank that is not subject to special receivership.
Ray, you got thoughts on that?
Yeah, I can tell you, I mean, federal bankruptcy, United States federal bankruptcy law is incredibly broad. And unless it's specifically carved out, which are banks and insurance companies, the federal bankruptcy law would likely trump any state law that would interfere with it. To answer your question, I mean, that is likely it. I mean, what's interesting to me is now, post Dodd-Frank and as you're getting forward, the battles now with insolvent banks, the crypto banks that have failed over the past few months and how they're getting resolved, because the way it was resolved in 2008, 2009 is a lot different than how it's going to get resolved now. And there's a whole lot more power thrown in the hands of the FDIC to liquidate those regulated financial institutions. But to answer your question, yes, the federal bankruptcy law would likely trump. And with good reason, by the way, because the federal bankruptcy laws are very well settled. They're very broad. They're very well designed to handle any kind of troubled company situation, whether it's a novel, industry or steel or airlines or whatever. It's very well set up to do that.
Yeah, and you're absolutely right. And what's the first thing you learn in bankruptcy law class? A bankruptcy judge can break a contract, right? So a lot of people who think they have contractual asset segregation to protect their assets in the event of a bankruptcy, unfortunately, as we've been discussing, have had to learn the hard way. They become a general creditor and everybody gets pulled together and takes a haircut. So now there's an interesting question coming back to the ETF. Given that there is not a bank other than Bank of New York Mellon that has the statutory receivership regime, what would happen in the event of a failure of the custodian for that ETF? I'm posing the question rhetorically. Everybody can start thinking through it.
Yep.
I'm really conscious of your
Sorry.
time, and you said you had a hard stop. I'm interested. I mean, obviously, your experience, for obvious reasons, is Wyoming, US centric, but you're obviously looking at sort of crypto and blockchain on a global scale. Are you looking at any markets anywhere else in the world and thinking they've got it right, or they're on a path to doing things right?
Lots of other markets. I mean, Switzerland has been out there. They've had their regime in place since 2017. And you know, you've definitely got a vibrant organization, a vibrant industry in Switzerland, where we haven't seen, to my knowledge, any big failure problems, including banks that are issuing Swiss franc stablecoins. 2 of them, I believe, last I looked, right? With the blessing of the central bank in Switzerland, right? So absolutely, there are places, Singapore as well. And the interesting thing that is really opening up right now is Hong Kong, because China, of course, made a big move against digital assets. But geopolitically, one of the crazy things that China did was try to, in my humble opinion, was try to shove the miners out of China, because that geopolitically meant that a lot of the hash rate migrated into the United States. Now the United States is the one shooting itself in the foot, and in reaction to the United States shooting itself in the foot, the Hong Kong is opening back up. And boy, have I heard a lot of very positive things coming out of Hong Kong. And you're actually now seeing the Hong Kong authorities are pressuring the big global systemically important banks, GSIBs, to open accounts for crypto companies. Again, most folks don't realize just how much of a vibrant offshore US dollar market there is. People don't need to get their US dollars from US banks. They can get their US dollars from offshore banks. It's called the Eurodollar market. It's existed since the late 1950s. And it's exploded in size in the last couple of decades. And that's how an entity like Tether can stay entirely offshore and out of the reach of US regulators, because there are allegedly non-US banks that are willing to give it US dollar clearing services. And now we're seeing that it's not just that, it's an outright welcoming the industry with open arms again into Hong Kong, and people are pouring into Hong Kong. So yes, there are other jurisdictions that, in my opinion, are doing it right. Europe, of course, with MiFA, has also made a big stride and is now clarified exactly what it's going to take for its banks to service digital assets. That's going to be very interesting for the non-US based GSIBs that have US intermediate holding companies regulated by the Fed. How is the Fed going to handle that? And I again come back to the illegal favoritism shown by US federal regulators towards the large financial institutions that are rolling out the red carpet. We saw this with the Fed's master account list, which it unveiled late Friday afternoon before a 3-day weekend, hoping nobody would see it. There is a investment bank in the United States that almost certainly is not legal for a Fed account, not eligible rather for a Fed account, that has one. There's a lot of favoritism being shown there, and it's not legal to show that favoritism when the law says the Federal Reserve shall provide services to all eligible financial institutions. But I laugh at the outcome of what's happening in Washington, D.C., because what they say is that they don't want the large financial institutions to get bigger. What's actually happened, as we all know, is the large financial institutions have gotten bigger.